All right? So tell me, what is the key difference between, what are the key differences between criminal law and civil law? Criminal law and civil law, Mr. Hassan.
Civil law pertains to the duties that exist between persons or between persons and their government, while criminal law contracts has to do with crime.
And so, when there is a breach of contract, right, who are the parties in that type of dispute?
In the civil law.
In the civil lawsuit, for example, under the context of a breach of contract, who are the parties?
That would be the plaintiff and defendant.
Okay, and who are the parties in the context of a criminal breach of duty? So if somebody violates a law, which is a breach of a contract, right, that is between you and who?
That would be you and the district attorney. Or, I mean...
And who is the district attorney representing?
The state.
The state. That's the concept. So we started off this class, right, at the beginning of the semester talking about what? Mr. Hassan?
Civil law.
Civil law, but specifically contracts, right? This is a business law course, right? So we talked about contracts. And again, in that contract, there's an obligation between the who? Who are the parties to a contract?
The parties to a contract. Promisor and
The promisor, what?
And the promisee.
And the promisee, right? So in the context of civil, I mean, that's, again, the civil law context. Now, in the criminal law context, there's also, again, the two parties, right? You mentioned that when there's a breach, the party that is seeking to, again, hold the other responsible is the who?
The other being the individual committed a crime.
So the other being the individual committed a crime, but the person holding that person responsible is the what?
The state.
Is the state. So that's the idea that you want to think of. That again, in the civil context, we have two parties who are engaged in a contract, right? And there being a breach of a contract, and that's what brings us to court to resolve that breach of contract. Or it may bring us to a mediation, right? We talked about the difference between a mediation and arbitration. It can bring us to arbitration, right? And that brings us to negotiation. Thank you. But in the context of a criminal matter, you have a contract also, and the parties to that contract are who?
The state.
The state and the who?
The person.
And the individual. All of us individuals, which we could also classify as citizens, are obligated to abide by the contracts of the who?
The state.
The state, right? And so criminal law is important for any business because you have to understand not only might there be civil penalties, again, breaking a contract to the individuals that you are responsible to, but there might also be obligation, there might also be penalties relating to, again, the contract that you have with who, Mr. Hassan?
State.
With the state. Okay, you got to see. So, now, tell me some of the key differences between the criminal law and civil law. Let's go to Mr. Willis. Go up and down, up and down.
The key differences between civil law and criminal law.
Mm-hmm.
In civil law, the issue Yeah, so in civil law, the issue of the party who brings the suit would be the person who suffered harm. And within criminal law, the party who brings the suit would be the state.
We talked about that.
And causing the wrongful act in civil law would be someone, it would be something done to another person, like causing harm, bringing damage to their property. And that's civil law. Criminal law, it would be violating a statute that prohibits some type of activity.
We talked about that.
And then civil law.
How about burden of proof?
Okay, yeah, the burden of proof. In civil law, the preponderance of the evidence. And
First of all, back up. What is burden of proof?
burden of proof is, well, my definition.
Well, give me your definition.
I would say that it's the proof, but like it's a substantial amount of proof that you'd be able to say, like this person did it, like with evidence, though. You need to bring evidence.
What does the book say about burden of proof?
In a civil case, the plaintiff must prove his or her case by preponderance of the evidence. Under this standard, the plaintiff must convince the court that based on evidence presented by both parties, it is more likely than not that the plaintiff's allegation is true. In a criminal case, in contrast, the state must provide its case beyond a reasonable doubt. If the jury views the evidence in the case as reasonably permitting either a guilty or not guilty verdict, then the jury's verdict must be not guilty.
So again, burden of proof is a good way of understanding that is the idea of evidence, right? And doubt. The evidence in the context of a civil case must be only like a vote, right? In an election, who wins? In most elections, right? You only have to have what?
The majority.
Which is what? What is the majority equivalent to?
The parties, electors or something. The parties side. I mean, electoral.
No, I'm saying in the context of a...
Like 3/4.
No. 3/4 is a what? In an election?
3/4 is dealing with like, it's doing something.
Pardon me?
What is it? You're asking what is having the majority mean?
Yes.
More than half.
More than half, right? 50 plus 1, right?
Yeah.
So again, it says that in a crime, the government must prove the defendant has committed each element of the defense, right? That's the burden of proof. Thank you. And so again, it's the idea of a preponderance beyond a reasonable doubt. That's the issue. The proof that a certain person committed a crime must be beyond a reasonable doubt. As opposed to, again, a preponderance of the evidence in the context of a civil matter. That's the key difference. So in a criminal case, you have to, again, any doubt in a criminal case, can be, again, enough to acquit. Any doubt. So did anybody see the movie Marshall, Thurgood Marshall? Anybody see that movie? In the Thurgood Marshall movie, you'll see that what the guy was doing at the end of the case, and perhaps we'll assign this, and we will assign this. I don't know if it's out on Netflix yet. But in that case, he had a cup. And he talked about the issues relating to that case. And he dropped a spot of ink in each again, to represent each issue. And at the end, he looked at the cup and he said, all these issues basically are similar to this cup. In order to basically convict him, you can't have any dots. But because you have all these dots of ink in here, this cup isn't clear, right? And this has to be also your mindset relating to this case. If you have, again, any doubt, if you have a reasonable doubt, then you cannot convict. And that's, again, the idea of the burden of proof. You have to convict beyond a reasonable doubt. So if you have a reasonable doubt, is a person guilty or innocent in the context of criminal? Innocent. Because you cannot have any reasonable doubt that that person is guilty, or that person is innocent, all right? So, you can have a seat now. Now tell me, what are the difference between a felony and a misdemeanor? Felony and a misdemeanor, Miss Green.
Felonies are a serious crime punishable by death or imprisonment for more than 1 year. And a misdemeanor is less serious crime, punished or fined. It's like a misdemeanor is like something that you steal in, but not still something big, like stealing candy or something like that. You will get fined, or you have to do a community service. And then a felony is like something really serious, like you murder or you kill somebody. You murder or you rape somebody or something like that.
So again, there are two things to understand, as you just said. One, that a felony is punishable by death or prison for more than a year. And a misdemeanor is anything less than that. You see that? Anything less than a year, okay? Now, tell me also, in order to be convicted of crime, what are the elements, what must be met in the context of a criminal offense?
You have to be guilty, and you have guilty.
What must happen in the context? What are the two elements that must be met of any or most criminal offenses? That's a key difference. I say I was going to say any, but I had to correct that and say most because of what I'm also going to talk to you about. But there are two things that must be met in the context of a criminal offense. Thank you.
It's the criminal act with state of mind.
It's in the Latin word is the what? Actus reus. Say it together.
Actus reus.
Everybody, actus reus.
Actus reus.
And the other is what? The mens rea. Let's say it. Mens rea. Together, mens rea. Now this is key. Actus reus versus the mens rea. The actus reus is what? The act. So, if the law says that you are guilty of striking somebody, committing an assault is, again, striking someone, or a battery being better is a better example, a battery being striking someone, right? So if I hit you, Miss Green, am I guilty of the crime of battery? If I hit you.
Yeah, that's the act, right?
I've committed the act.
Well, okay.
That's right. You don't know if I'm guilty because of what? Because I could have hit you in order to prevent you from what? From being struck by a bullet. Right? So if somebody is shooting at you and I push you down, in order for you to be able to avoid being struck by a bullet, am I still guilty of battery?
No.
Because what?
The state of mind.
Because I don't have the mens rea. I hit you in order to be able to prevent your harm, to protect you, right? So again, those two things that have to be met in the context of a criminal act or criminal offense. In most cases. However, there are some cases in which there is no state of mind. Because again, in the context, for example, of criminal negligence or recklessness, you may not have a criminal mind. What does it say about that? What does it say about? Again, the idea of recklessness or negligence.
Okay, recklessness. A court can also find that the required mental state is present when defendants act in recklessness or criminal negligence.
Negligence.
Yes. A defendant is criminally reckless if he or she
What'd you say?
Would constantly degrade a substance and unjustifiable risk.
So the point is that if a person, even if a person does not intend to do you harm, right? But he acted or she acted recklessly in disregard to your well-being. So, for example, if I was in this classroom and I was basically just, checking out a new gun that I bought, just firing it off, like, man, let me see this gun work. Pow, pow, pow. And I just, pow. My arm jerked and hit Mr. Hassan. I didn't intend, right? I didn't intend to hit him, but I hit him with the gun. The bullet struck him. Sent him to the hospital. And then the court comes up, and I'm before the judge, and the prosecutor says, well, he's guilty of battery, right? I say, no, Your Honor, I didn't intend to shoot my student, right? Why would I want to shoot my student? However, what would the prosecutor argue, Ms. Green? That I acted recklessly. Why were you basically doing some target practice in your classroom, Professor Karim? That makes not even is it negligent, but that goes to reckless. Now give me an example of negligence.
Dr. Michael Jackson was convicted of involuntary manslaughter in 2011 for prescribing the drug that led to Jackson's sudden death in 2009, where he had given Jackson a powerful medicine normally used in surgery as a sleeping aid, and the night of his death, even though he knew that Jackson had already taken other drugs.
Very good case, and in fact, I'm personally aware of this case because the defendant was a constituent of the member of Congress that for whom I served as chief counsel at the time of Michael Jackson's death. So she had two interests. On the one, his doctor was, again, the constituent of Congresswoman. She was actually Lee because he was from Houston. And then on the other hand, Congresswoman Jackson Lee was close to Michael Jackson. Was one of the few members of Congress who had embraced Michael Jackson after some of the scandal. And so she was invited to actually come and speak at his funeral. So it was a very conflicted situation with respect to that particular case. But in this instance, what they were saying is that, again, him prescribing the drug was not reckless, right? Because in some cases, prescribing the drug for sleeping could be reasonable. But again, his lack of diligence with respect to, again, how that drug was administered, and perhaps the dosages all contribute to a lack or a breach of what any other doctor would do. So that's the idea that you want to think of. What is the reasonable person? What is the reasonable person going to do? And we'll get more into that, or you would get more into that if we have enough more time in the semester to get to torts. But the reasonable, again, the idea of negligence is the body of tort law, primarily, right?
What is tort law? What is tort?
A tort, as I was saying, is again a theory of law that deals with the breach of a duty based upon what a reasonable person would do. So it's a contract that's kind of unwritten, but it's based upon what a reasonable person. So in idea, going back to the example of me and having a gun, right? So if I was, again, doing target practice in this classroom, again, that would not only be a breach of what any other professor would do, right? But that would be, again, reckless disregard. So that's going to not only negligence, but that's reckless.
Oh, it's like an unwritten contract or agreement, as you should know.
It's unwritten contract, exactly. But the other, an example of that being, again, negligence is what? A negligence example might be I wasn't, again, doing target practice in class, but I had the gun on my desk. I just had the gun on my desk here, and I didn't know that it was loaded. I didn't know it was loaded. And in fact, let's not even say that. I had the gun in my pocket, right? Again, and it was on, right? And I took off my jacket and put it down on the desk, and it fired and shot you, right? In that context, the question would be, why did I even bring the gun in the classroom? Is that reasonable for me to have brought this loaded gun, right, in the classroom? Is that reasonable? Some would argue that it wasn't reasonable. I had no threat in the classroom, right? Why would I have brought a loaded gun in the classroom? So again, that breaches the standard of what a normal professor would do. So that's what you have to think of. What is the context? Who is the person doing that? And what is the context? Right? And those are the things that are taken into consideration when we talk about tort law. And that's what goes with the issue of negligence, all right? And the mindset. One last thing that I want to hit on quickly before we call our speaker is the, thank you, is the issue of, you can have a seat. What is another issue, Miss Hodge, or I'm sorry, Miss Kale Hall. Tell me, what is another issue that eliminates the requirement of a intent in the context of criminal law? Where no intent may be required.
Strict liability.
Tell me about that.
Strict liability and over criminalization.
Mm-hmm.
Basically, an increasing number of laws and regulations impose criminal sanctions for strict liability crimes. Strict liability crimes are offenses that do not require a wrongful mental state to establish criminal liability.
And where are these kind of strict liability crimes found most?
In the federal crimes.
In the federal criminal code. There are over 4,000 criminal offenses that, and over 10,000 federal rules can be enforced through criminal sanctions that do not require an intent. These include environmental crimes, drug offenses, and other violations affecting public health and safety and welfare. And so the question's always been asked, well, why are we creating these criminal, these crimes that can be done even without you even knowing that there is, first of all, a crime. So again, if I commit a crime and I say, well, hold on, I didn't even know that was a crime, am I innocent? Am I innocent?
No.
No. So one, people are being convicted based upon the fact they might not even know something is a crime. And then second of all, if you eliminate, again, the criminal intent and say that you can be, again, found guilty even if you did not intend for that to happen. Again, that creates an issue of a lack of fairness. And I'll bring this up because for many years, the chairman of the House of Representatives Judiciary Committee is John Conyers. Congressman John Conyers was one of the vocal opponents for the inclusion of crimes that oftentimes have a disproportionate impact on who? People of color, right? And people without money, period. Caucasians alike. Because again, if you don't have resources, then you're often, again, without a lawyer, right, who can advise you on what, again, your rights are, what your obligations are. And so again, the crimes and the criminal code, particularly the federal criminal code, is really, again, stacked against the small guy. And Congressman Conyers has been, again, a vocal opponent of that type of, stacking the decks against the small guy. The reason I bring him up particularly is because, have anybody heard any news about Congressman Conyers? So Congressman Conyers currently is under, again, a so-called cloud of suspicion because of what is happening with respect to the reporting of sexual assaults or sexual abuse, right? And in this context, he has a lawsuit that was filed against him. He settled the lawsuit. And so people are now calling for Congressman Conyers to resign. The question I ask is that, again, I've given you a small example of some of the things that the congressman has done. The congressman, is anybody familiar with the Martin Luther King Jr. holiday? We all get off of that holiday. Congressman Conyers, that was Congressman Conyers' bill. He was responsible for passing that bill, so we all benefit from the MLK holiday. And many, many other things that you don't even know about. And so the question that I ask is that even if what these women are saying is correct, and I'm not going to, dispute whatever the women are saying, because I'm not the judge, I wasn't there. And I'll assume whatever they're saying is correct. The question is, when we as a community or as a people, what are we going to, the question is, what are we going to do, right, when these allegations are made? Particularly with respect to people who have made serious sacrifices, right, for the community. Do we wipe away all that they have done? Or do we take it in balance and make a decision relating to both what was, again, alleged and what they have done that is without doubt, right? It's without doubt you pass the, again, the law that allows MLK holiday. It's without doubt that he pushed for, again, increases in civil rights enforcement, and in particular in the Department of Justice. It's without doubt that he fought against, again, the over-criminalization of people through the increases of the strict liability-related laws in the federal code. It's without doubt of those things, right? So again, the idea of law is based upon what?
Check the balance.
It's based upon balance. Have y'all ever seen, again, they call it the Lady Justice? She's carrying what? Scales, right? Scales equal, again, a balancing of good versus bad. No one should be basically found guilty just merely, or no one's life should be, again, classified merely based upon their bad. I'm sorry, you can have a seat with this. That's all. based upon their bad, right? But you should be able to look at, again, the totality of what has happened and then make a decision. Does that make sense to you all? With that, let us bring on Attorney John Greenberg. Can I, you have a phone? Your, you put that yours on? He call. We give you a number to call. We're going to have Greenberg get on this. One of the speakers. Attorney John Greenberg. Phone number is 703 867 7371.
Hello?
Yes, Attorney Greenberg.
Speaking.
This is Professor Karim. How you doing?
Hi.
Great, great. We apologize for the time, but we want to give our students an opportunity to speak to you and give you an opportunity to speak to our students. So we have your bio up, and we won't read it, but I think all the students will give it a chance.
I'm not getting very good reception. You know, I just got to my office, so I can give you my office number.
Okay, what's is that the, all right, what's that number?
202.
Okay.
662.
Mm-hmm.
8315.
Okay, about to call you right now. Hold on one second. Let's can you say that. How do you say call this number? Oh, no, that's number right there. Can you call that? Oh, you want it? 202 662 8315.
8315.
I thought it was 86.
I think it's 8.
Hello?
Yeah.
Attorney Greenberg?
John Greenbaum. Yeah.
Greenbaum. All right, my apologies. Attorney Greenbaum is the Chief Counsel and the Senior Deputy Director for the Lawyers Committee for Civil Rights and the Law. And again, lead counsels in the, what case, class?
Coalition of Equity and Excellence in Maryland Higher Education versus Maryland Higher Education Commission.
Excellent. Okay, Attorney Greenbaum, we apologize. We don't have the full 30 minutes for you to speak. But I'm going to ask my class if we can get at least an extra 5 minutes of their time, so you can give us. Can you give us what you think? Because we know this case, and we've come up with some of our own remedies. But what are the remedies that you guys are proposing specifically for Bowie State University?
So first of all, thank you for allowing me the time to talk to you, and we really appreciate the support that we've gotten from the students and the alums of Bowie State and the other HBCUs during the whole course of this case. And this is a very long case. Was brought in 2006. We and the Kirkland and Ellison Law Firm, and it was actually brought originally by the Civil Rights Clinic at Howard University. In 2009, the Lawyers Committee in Kirkland and Ellis got involved in the case, and have seen it through for the last 8 years. 2 long trials, and we're finally at the point, as you know, where we are looking to develop a remedy. The thing to keep in mind in this case, including when it comes to a remedy, is the fact that this is a case involving the issue of segregation, and that the bottom line and goal of the remedy is to make each of the 4 HBCUs more attractive to students of all races, and that the means for doing that case, that's the theory that the judge accepted. We had a number of other theories during the course of the case that we did not win on, including changing how the schools are funded for operational expenses and changing the way the schools are funded for capital expenses.
So you mean to say that the state of Maryland can still continue giving less funds to Bowie State than it does per student to University of Maryland College Park?
That is not directly affected by this case, the funding formula.
So they can continue to basically discriminate in funding.
The judge ruled the law is very complicated here. In order for us to prevail on any of our theories, we have to show that a current policy or practice traces back all the way to the era of de jure segregation. It's a very high, difficult standard for plaintiffs to meet. And with respect to the funding formula, the court found that there was no current practice that's traceable to the pre-Brown versus Board era and that has segregative effects.
Wow. So okay. So what would be one of the remedies specifically affecting Bowie State?
So, and this is not just true for Bowie State, but it's for all the schools. Like I said before, the idea is taking sort of the foundation of each school already. How can we build out some programmatic niches so that each of the schools has an academic that has a programmatic identity associated with those niches, such that the schools are able to attract students of all races.
So like cybersecurity, for example, or
so here's an issue with cybersecurity is that one of the challenges, the history of this has been that, and I don't know if you studied this in your class, Bowie State used to have, in the 60s and the 70s and into the 80s, Bowie State was much more racially mixed than it is today. And what Bowie State had at the time it had certain areas in which students of all races were attracted to those classes because there weren't other schools, and particularly traditionally white schools, in the system that offered the same classes. And this comes back to the pre-Brown versus Board era, and the creation of HBCUs, where HBCUs were created to allow African Americans to get an education when African Americans were being prevented from being able to go to the traditionally white institutions. And what that typically meant was, in this case in Maryland, that the HBCUs were created for that reason and were treated like second-class citizens. And second-class citizens in many ways, second-class citizens in terms of facilities, but also second-class citizens in terms of programs. So that the idea was that if you were a white student, any class, any program that you could take at an HBCU, you could take at a TWI. And so there would be no need for you to go to an HBCU.
Basic duplication of programs, right?
Duplication of programs, exactly. And so there was a period of time in the 70s and 80s where HBCUs had some programs that were unique to it. Like, for example, the most dramatic example was Morehead had an MBA program. And it was the only public school in the Baltimore area that had an MBA Baltimore. It had been a private institution that was failing. We bought it in 1973 and had it become part of the public system in 1975. And University of Baltimore had an MBA program. And what ended up happening was the white students simply chose not to. The white students were attending Morgan, and that largely stopped once you had an MBA program at University of Baltimore. And, that has continued to happen in the future, up until today. And what tends to happen is, and what makes it challenging for the HBCUs is that the TWIs are in a better position to create new programs in the first place.
Right.
Like take cybersecurity, for example. I'm sure that probably a lot of you have seen the ads about UMBC's cybersecurity program.
Right.
Or UMBC's cybersecurity program. So, if Bowie wants to start a cybersecurity program, it's already at a disadvantage in terms of doing that.
So we would have to come up with
because of the way that the system is set up.
So we would have to come up with something unique, like for example, a autonomous vehicle program or a Bitcoin technology program, something that's unique and nobody else is doing essentially, and then that get funded, and that might be the type of remedy.
Right.
Okay.
Those are along the lines to be thinking of. Now I want to add a couple things to that. The uniqueness is important. The other thing is, and having the resources is important, but a couple of other things that are important too is it needs to be you can create a new program, but if it's not a new program that students are interested in, it's not going to have any effect. It won't attract any students, and you haven't moved the ball.
Right.
So you're not only looking for a program that is unique and distinct, you need to have programs that are high demand, that students are interested in, that want to take. And then the other thing is that it has to be tied to what are the existing strengths of the university already. So, for example, Bowie State, for UMES, which is in part an agricultural school, one of the ideas that's been thrown out there is a veterinary medicine program. And that might make sense for UMES. It wouldn't make sense, though, for Bowie to propose a veterinary medicine program because it's not connected to what the existing strengths are for the university. So, instructing this.
I want to open up the floor to some of my students. One of the questions that I'm sure they're going to probably also bring up is the question about moving programs. So you talked about UMUC having a cybersecurity program. Under the remedy, why not again have the cybersecurity program be moved from UMUC to Bowie State?
Yeah, well, we pressed on that issue. We identified potential programs to be rejected and to be transferred, and the judge essentially rejected that. So there might be an instance in which the TWI is willing to give up a program that can be transferred, but that is not going to be a significant part of this remedy.
All right, so we got some hands up. Mr. Tucker?
Yes, I have a question. So, when I'm hearing from what you're saying, one of the main goals is you're trying to make the HBCUs more diverse. That's correct?
That is correct.
And the reason being for funding purposes to sustain the schools in the future, or
The theory is based, and this goes back to a Supreme Court case from 1992. And one of the things that happened in the 1970s and 1980s is that there were a series of cases brought in states like Mississippi, Alabama, Tennessee, and others that developed the theories on this. And there were a lot of different approaches that the lawyers who were trying to improve the HBCUs try to develop in the course of these cases. And the one that the Supreme Court found to be persuasive had to do with the concept of desegregation and the fact that if you had situations where HBCUs were segregated, that could create a legal violation under certain circumstances.
No.
So I hear your question. It's one of the tensions in the case that what success means in terms of a successful remedy is going to mean some degree of changed demographics at the HBCUs. Now, do I think it's likely in Maryland that any of the HBCUs anytime soon are going to be majority white? I would be very, very surprised if that happened. But the remedies are geared toward trying to make the HBCUs more diverse.
And no, I was just trying to figure out, and I understand that, and that's good. But what would be the benefit for the students? That's what I'm saying, making them more diverse.
All right. Well, the theory behind the benefit for the students is to make that on a couple levels. One is it gives the students a more diverse experience. All the students a more diverse experience. The African American students, the white students, Latino and Asian students. That it creates a more diverse, less segregated environment, and that a second byproduct of that is the potential to improve the status of the universities by giving each university some signature programs that people identify with in terms of the school, and that has the effect of raising the visibility of the university. And one of the things I should mention that a component of the remedy is going to go to things like advertising, scholarships, and other institutional support.
How about facilities?
Well, facilities are a possibility if it's tied back to particular programs.
Like, for example, the football stadium at the University of Maryland College Park, man, is amazing. But the football stadium here at Bowie State, is worse than some middle school football fields.
Yeah. So, what I would say to that is that the remedy that we had a capital facilities claim in the case, we lost on that claim. So the remedy is not directed at capital facilities. But if on the other hand, what there needs to be in order to create these signature programs at the university are either new facilities or facility upgrades that come along with that, then that's something to be considered. I think in most cases it's going to be the other way around. And so, for example, Bowie's got a new building that has it opened up by now.
Yes.
So, and if the feeling about that new building is this is a state-of-the-art facility that, for the programs it offers, has the opportunity to elevate those programs, I think what's more likely to happen is to really sort of build off of existing strengths. So what's gonna happen in the case, and I think this is important to understand, is that the remedy is going to be in effect for 10 years. That the parties in the case are going to recommend, the judge is going to appoint a special master. And that special master will create some committees. The special master will be taking input from the parties in the case I'm sure, from faculty and students as to what should be done as a remedy in this case. And so people are going to be making proposals and are going to be interacting with that special master once the special master is appointed.
How is that special? Is there going to be an application process for the special master, or is she just going to choose on her own?
So the parties are going to suggest potential special masters, and she might choose somebody that we suggest, or she might choose somebody on her own. And there are a couple of ways that she could go with that. She could go with somebody who has significant educational experience in higher education, including high-level administrative experience. In our view, it would need to be someone who has substantial background at HBCU. The defendants don't necessarily share that point of view. It could be somebody else. It could be somebody like a lawyer or a former judge that would then go on and appoint a committee of people that have some deeper educational experience. So it's basically going to be the two sides of the case. You're going to propose people, and the judge may take one of those people, or she might choose somebody on her own.
Okay. One last question.
But I will say that it's going to, for whoever it is, it's going to be a big job, because and what's going to happen is that special master, and I think she gives the special master a period of time. It might be a year to propose a plan that she will then review and determine whether to go forward, or whether that plan goes forward, or whether she's going to make some changes to the plan, or what's going to be done from that point.
Okay. Any last questions? One thing that we were talking about, John, is the issue of gentrification, which is happening, especially in D.C. And all around us. And the fear is that if you get this new money coming into, let's say, all the HBCUs, then where will and then there's, again, everybody seeks to come in, do demographics come in, like is the case in D.C., then the African American indigenous population is pushed out. And now they don't have a place to live. Likewise, there might not be, again, slots for, again, the students here. And the curiosity that I had is, how could the judge say that you have diversity at the University of Maryland College Park when our student, Lieutenant Richard Collins, my own personal student, was shot or stabbed to death on that campus? And that's not the first, racial incident that happens. And you have such a minority of African American students on that campus.
Sure. So keep in mind that the standard here is a very high standard. You have to show segregation. So you made two comments. I'm going to try to address the second one first. You made 2 points in your comment about the situation about the TWIs. There wasn't any evidence showing that there was a legal violation involving intentional discrimination in, let's say, admissions at the TWIs. The very high standards to meet. We didn't try to make that argument in this case. I mean, this case was essentially brought on behalf of a coalition who wanted to improve the situation at HBCUs. So this case is not TWI focused. The gentrification point is a legitimate one in terms of, okay, if we're going to change this university and that's something that's going to have to be thought through as part of the remedy. And as I said before, I don't think we are talking about a situation in which we're going to come back to Bowie 5 years from now and 70% of the student body is going to be white. I just don't think, having studied this and having studied what happened in Maryland and at each of the 4 HBCUs over the years, it's hard for me to imagine that happening. Our goal, like I said before, is to make the campuses more diverse. It is to create some new signature programs at each university that are more diverse. Now, that can have a lot of positive effects in terms of bringing up and providing more aid to the students that are at the school, increasing the visibility of the school. But yeah, it's something that the schools and the special master and the parties, we'll have to keep an eye on is what are the potential downsides of this change as well.
Oh, okay. Well, I appreciate that, John. I mean, and again, we salute what you guys are doing. And it's clear to us, I mean, that even though you all were not able to show particularly discrimination at the University of Maryland's College Park and other campuses that are not HBCUs, there's clearly evidence of discrimination. And again, you only point to that killing of Lieutenant Richard.
That was not the case that we brought, though, and that's not the case that our clients asked us to bring.
Sure, no, we understand. We definitely understand, but we understand again the difficulty in bringing such a case also. And I just hope that the judge at least has in her mind an understanding that, again, if we diversify the campus of the University of Maryland, diversify the campus of Bowie State, for example, and at the same time, you're not diversifying to the same extent, right? The campuses of the University of Maryland's College Park, for example, University of Maryland College Park. I don't know what the population of African American students are there, but it would seem to me that if you increase, let's say, increase the Caucasian population here at the Bowie State to 20 to 30%, then equally the population of the University of Maryland's College Park should be the same percentage of African Americans. And if you don't have that, to me that again creates it basically goes against the intent of at least even if it's not written intent, at least the implied intent of this case.
Well, here's something else to consider, and that is that one of the things that could happen at Bowie, let's say, is that there isn't a decrease in the number of African American students at Bowie based on what happened. That instead, there is an increase in the number of, let's say, white students. And instead, what's happening in the university is the remedy gives the university an opportunity to expand its enrollment. Because it is offering, it's not necessarily taking away the existing programs that it has today, but what it's doing is it's something that's additive.
Right. I can get that, and I think that's again, so long as there's there's room. Again, we don't have like a kind of an ethnic cleansing like we see in D.C. where they're being pushed out and there's no place to go. So long as there's again porous borders, if you will, right? So we have the same opportunities for African American students to go to the University of Maryland College Park as we have for Caucasian students and other students to come to to the Bowie State, then I think that everybody is well served. But if there's, again, there's not that balance, then, justice isn't served, at least from what we see.
I understand your point. It isn't, like one of the things that isn't part of the remedy is for the TWIs to have to look at their admission standards. So I want to be clear that, and I understand that changes can be made outside the context of the lawsuit. We can't, for example, propose to the court that, well, you need to change your admission standards at College Park or UMBC or wherever as part of the remedy.
Right. Yeah. Well, look. Thank you so much. Let's give a round of applause to Attorney Greenbaum. I know our students stayed here to actually hear the last comments. And Attorney Greenbaum, we look forward